Good morning, everyone. Welcome to another YES Talk, YMC Education Series Talk. Thank you for joining us. My name is Pam Rakansky. I am the YES facilitator here at the North Suburban YMCA. It's my pleasure to welcome you today to Matt Margolis. Yay! He's going to be talking about tips and tricks for the child caregiver. So we are excited to hear him talk. He is an elder law attorney and will offer planning strategies and important matters to consider for adult children when they realize that they will need to help care for their aging parents. So with that, I will leave this to Matt. Please welcome Matt.
Hey, thanks, Pam. Good morning, everybody. All right, so if some of you have seen me talk before, you probably know what I'll say, but so my name is Matt Margolis, and my partner Lauren Malden and I have a boutique elder law and estate planning practice in downtown Park Ridge, and we help folks with all sorts of folks with estate planning matters, 18-year-olds putting powers of attorneys together for 18-year-olds going off to college, all the way up to just doing, sort of traditional wills, trusts, and estate planning for, married couples, single individuals of all ages and all family types. And then the other half of our practice is the elder law side, which is helping folks sort of navigate all those issues sort of that surround, dealing with a loved one that has an acute or chronic medical issue or disease that they're trying to plan around, whether that's applying for Medicaid, benefits through the VA to help pay for care, and really just be a resource for families that have a lot of questions and need some help. And in a lot of cases, we can help with a really small piece of the puzzle. And we're really good at helping put them in touch with a lot of the other people out there that can help serve all the other needs that they have. Because when it comes to those types of situations, there's a lot of people that they need to work with and that they need help from. So that is my short and sweet story about who we are and what we do. So today we are going to talk about some tips and tricks for the child caregiver. So we see a lot of this. And then what I'll say is, if anybody has any questions, please put them in. I would ask that you please put in the chat box. I will keep the chat box open on my end. If it's, I may look at the chat box and answer the questions, as they pop in, if it kind of makes sense. Otherwise, I might just wait till the end to answer them. But again, if you have any questions, please get them in there. If you're like me, if you don't get it off your chest, you'll forget. So, when we, in our practice, and I've been doing this now for 12 years, there's a lot of pressure on the child caregiver, and this is not very, it's very similar when you have a spouse who's a caregiver as well. So there's a lot of similarities here when we're talking about the child caregiver or a spouse as a caregiver. We're talking about, obviously a very, very close relative, in either case, a very close loved one who, is caring for either a parent or a spouse who's all of a sudden not doing so well from a healthcare standpoint. And that's difficult, right? It's difficult when somebody sees a spouse failing from a healthcare standpoint, and it's difficult when we see a parent starting to fail from a healthcare standpoint, right? Because our mom and dad, they were always strong, right? They were always there for us. They were always the ones taking care of us. And now all of a sudden, we're seeing that they're vulnerable and they're not as strong as they once were, and that they're not, this, invincible person that we thought that they were. And I was talking to my wife last night. My dad's going to be 91 later this year, and I have this conversation with my wife a lot recently, that I've got these 3 older half siblings that I think are very unaware of how old my father is, right? And I think a lot of us fall into this trap of just not being aware of how, in some situations, how frail or how much help, or how much how much our parents have declined, right? And it's just because it's a defense mechanism, right? We just don't want to believe that they have declined to a certain point. We don't want to believe that they're getting to a certain point, right? So, there's an aspect with the child caregiver that becomes difficult because there's a psychological standpoint. It's not just the caring standpoint, but it's also being very aware from a psychological standpoint. And so it's very important for the child caregiver to make sure that, they're not just, it's easy to get caught up in taking care of a loved one. Very easy to get caught up in the day-to-day of making sure that dad's getting dressed and dad's being fed and there's groceries in the fridge and dad is being taken to his doctor's appointment. But that child caregiver, and if any of you that are listening in, if you are in fact a caregiver, you also need to be making sure that, your own well-being is being taken care of and that you're taking care of your own needs. And this goes for any caregiver. Again, this is not just an adult child. This is a spouse too. Because I think one thing that caregivers tend to do a really poor job of is take care of themselves. Okay, so I'm not a psychologist, I'm not a doctor, I'm not going to pretend to be one, but so I will stop saying this. But the last thing I will say is that make sure you're taking care of yourself, because it's really important that you do. And you are not going to be able to take care of your husband or your wife or your mom or your dad if you let yourself go, and if you don't take care of yourself. Okay, so that's all I'll say. All right, so now let's talk about the legal aspects of things, right? So first and foremost, right, if you've seen enough of my talks, you know that, I just am the most boring person in the world because I like to talk about powers of attorney all the time. And so you're going to get it for a couple minutes here. They're important, guys. And I will tell you, I will hammer them to death because, once again, I had clients come to my office earlier this week, right? Married couple, married for, 40, 50 years. And, of course, it's always the story where the wife, husband's telling me that the wife's illness, like all of a sudden just took like a really sharp decline, right? A sudden decline. Because now all of a sudden we're rushing to get estate planning documents together for him. And listen, if when it comes down to putting power of attorney documents together, and in Illinois, we have two types of power of attorneys. We have healthcare and property. These documents are so that we can name somebody to make decisions for us in the event that we cannot make decisions on our own. Okay. And so we've got a healthcare power of attorney where we name somebody to make medical decisions for us. And we've got a property power of attorney where we can name somebody to make financial decisions for us. And again, the idea is if I become incapacitated at some point, I need that healthcare power of attorney to step in and make decisions for me from a healthcare standpoint. If I'm incapacitated at some point, I need my property power of attorney to step in and make financial decisions for me, okay? A property power of attorney is not just who can make real estate decisions for me. Some people are a little confused and they believe that the property power of attorney, excuse me, is only related to property in the sense of real estate. It's not. It does include real estate, but it also means who can deal with my bank accounts, my IRAs, my 401ks, who can deal with filing my tax returns, anything that's not healthcare related, okay? And I can name different people, right? There's certain people I might name to make medical decisions for me, one at a time, right? I might name Pam first for healthcare, and then Jacqueline second, and then Aisha third. But when it comes to financial, it might be, Jacqueline first, Aisha second, and Pam third, because that might be the right order for financial, right? For the property power of attorney. It doesn't have to be the same order. People have different strong suits, right? And I always tell my clients, you need to be selfish when you're picking your powers of attorney. It shouldn't be, well, I don't want to hurt my daughter's feelings because, she's the oldest, but, my son, who's the youngest, would really be the best financial power of attorney. No, pick your son. And then don't worry about, hurting your son's feelings, who's the oldest, because you pick your daughter first and she's the youngest because she's the best healthcare power of attorney. You need to pick the best person for the job. That's just how it goes, okay? You pick the best person for the job when it comes to your power of attorney, because when a medical decision has to be made or a financial decision has to be made, you want the best person to be making that decision, okay? But again, you can name as many people as you want on your power of attorney document, but you have to be naming them one at a time. Okay, so I can name 4 people in a row, but they're named individually. I can't name Robert and Jacqueline to act together. Okay, Illinois does not allow that. So the issue that we see all the time, and here's the thing, so just so everybody's clear, and Missy, I know you just joined us, if you can mute yourself, just so there's no background noise, if you don't mind. Nice to have you. Just so everybody's clear, if we don't have a power of attorney for property or a power of attorney for healthcare, and I'm incapacitated, okay, so let's say I don't have a power of attorney document and I'm incapacitated, okay? And I'm incapacitated to the point where a doctor says, Matt, you cannot sign a legal document. You cannot sign a power of attorney, okay? The only way that somebody can then step in to make financial decisions for me, and there's a backdoor way for medical decisions, and I won't go into that. I don't want to waste the time to do it, okay? But specifically for financial decisions, the only way for somebody to make financial decisions for me, the event that I do not have capacity, is that somebody would have to hire a lawyer and petition a court to be my guardian, to be my legal guardian, okay? And listen, a guardianship is not, it's not the end of the world, but it's not ideal. A guardianship is going to cost, realistically, it's going to cost a couple $1,000s, and it's going to take some time, and you're going to go to court, okay? So again, not the end of the world, but not ideal. A guardian also has to check in with the court. You have to get the court's permission to do certain things. Most of us don't want to do that. So it is so important to get power of attorney documents in place. And I say this and I beat this to death. Okay? I beat this to death because it's unfortunate, but it happens too often that people come to us. This couple this week, they come to us, and the husband has capacity. He will be able to execute powers of attorney and estate planning documents, you know, a will or a trust or whatever planning we end up doing. But his wife very likely will not be. And she will very likely have to go through a guardianship. You know, there's a question in the chat box, what's considered incapacitated? You know, ultimately, that's going to be something that a doctor is going to determine, right? And I know I use the term incapacitated. I mean, basically, a doctor is going to determine, does this person have the right, it's hard for me to give a definition. Does this person have the right mental capacity to understand what they're signing, to understand that that they're appointing somebody to make decisions on their behalf? And so there's situations where, you know, somebody will either present themselves in a way in our office where it will put me on notice, or most of the time, you know, the husband or the wife who is more of the well spouse will tell me, you know, my wife has been, you know, was diagnosed with dementia, but it's early stages, or my wife's memory has not been that great lately, or sometimes it's the adult child making an appointment for their parent. And, you know, I will ask how mom or dad's capacity is, because a lot of times there's a reason why the child is making the appointment. And so what we'll do in those situations is we've got sort of a form letter, and I can't speak to what other lawyers and other estate planning firms do, but, you know, we sort of have a form letter that we'll give them, and we'll say, okay, we'll give this letter to the doctor, and if the doctor will sign off, and it's basically a fill in the blanks. It says, you know, so-and-so is my patient. You know, and in some cases, it's like, while they do suffer from dementia, they still have capacity to sign powers of attorney. They still have capacity to sign a will or a revocable living trust. Somebody can have a diagnosis of dementia and still have capacity. It could be early stages of dementia. Again, I don't play doctor. You know, I mentioned that earlier. Some clients that have actually can have pretty moderate dementia can do a really good job of fooling me and fooling others, right? So I'm not going to be, you know, pretending to start asking them the date and the president. And there's some lawyers that do that and they're comfortable with that. That's fine, great. That's not us. Doctor will make that call. The doctor says it's okay for them to sign powers of attorney or legal documents. Great. Now that we have it in writing by a doctor, we're good. This is also protection for the family later on. Why? Well, what if they are also executing a will or a trust with us? And what if in that will or a trust, the couple or the individual is maybe excluding a child or a grandchild or somebody from some kind of an inheritance? Well, if that child, were to contest the will or contest the trust upon the passing of my client, what if they contested it based on saying, hey, my mom had dementia. She didn't have capacity to execute the trust or the will. Well, if we have this doctor's letter that says, hey, she did, the doctor signed off, the doctor said she did have capacity to execute the trust, that really blocks that argument right away versus us not having that in writing. And then there could be like a pretty long court battle and a lot of money being spent. Okay. And those things can get really messy, like a very messy divorce. Okay. So I hope I answered that question in the chat box. The second part of the question, I'm not so sure. How does that get done so the POA is useful? I might need you to elaborate with a follow-up message in the chat, please. And I'm happy to, if you can clarify that second part, then I'm happy to touch on that. But I'm going to move on. So get those power of attorney documents in place, because you don't want to be, listen, these are simple documents. I understand that. People look at them as being very simple. The one thing I will advise, please, and I don't care if you come to me, go to another lawyer, but work with a lawyer, please, to put power of attorney documents together. Don't get them online. I've had clients put them together that they've gotten them online, they've done them themselves. Inevitably, if a power of attorney, even though people look at them as being very basic, and I agree, they are not insanely complicated, okay? However, if you execute them wrong, I've had clients where they were executed wrong, or in some cases, they didn't realize that they could name, successor agents. So maybe they just named their spouse, or maybe they just named their one child, but they have 3 children. Let's put some backup people on there. What if your one child is incapacitated? What if your one child is unavailable to make a decision for you? We want some backups on there. This is an important document. I really hope it's clear that it's important, right? If you're incapacitated, this person, you're using this document for somebody to step in and make decisions for you for the rest of your life. Okay. My 2 cents, it's worth it to spend a couple $100 is probably what you're looking at from any given attorney in the general area. It's worth it to make sure that this is done correctly. Okay. You can say I'm biased. I would agree, but honestly, it's not worth it to play around here and to have this done incorrectly, and to be in a situation where you don't have a power of attorney that's effective, or you don't have a power of attorney that was fully thought out, or that was old. Maybe you found one online that was from 15, 20 years ago and you didn't realize it, right? And it's not up to date, and there's certain things that's missing that you would have benefited from, etc. Okay. All right. One of the biggest things that we see for child caregivers, and I'm not saying this is everything, and I'm going to get to that question. I appreciate that follow up in the chat. I'll get to that a little bit later. Okay, so just because I'm moving on. One of the things that we see often with child caregivers, and it's just what we see in our practice, is there tends to be a situation where the child caregiver has put their life on hold, right? In some cases, it might have been a situation where maybe that adult child never worked, or never had a real career, and that child, was really just always there to sort of take care of mom and dad. maybe that child did have a career at some point, and that child left their career to start caring for mom and dad. And right, so we've seen both of these situations. And in either case, at some point, I mean, that adult child needs money to live off of, right? I mean, let's be honest. And so when we meet with these individuals, when we meet with the adult child and with their mom or dad, as attorneys doing what we do, and we do a lot of work in the Medicaid space. We help people apply for Medicaid, and one of the big things with Medicaid, for those of you that are not aware of how Medicaid works, is that when you go to apply for Medicaid in a long-term care facility, most commonly will be a nursing home that people are applying for Medicaid in. Medicaid has a 5-year look-back period. What does that mean? That means that when I go to apply for Medicaid, they're going to want to see, what did I do with my money over the last 5 years? Okay. And really they're concerned with, did I give any of it away? They don't care if I bought myself a $500 leather jacket. They don't care if I, took a $10,000 trip to Florida. They don't care if I bought myself a $2,000 flat screen TV or a $1,000 iPad. They care if I'm writing my daughter checks for $1,000 a month. They're going to care a lot about that. Medicaid, what they call it is they call that a transfer for less than fair market value. Okay. They don't care when I spend money on myself. They care about me giving money away to somebody else. So I get it. I tell my, caregiver children of clients, I understand that it makes sense that you would need some help from your parents, whether they're giving you money directly, whether they're paying for they're making your car payments, they're making they're paying for your cell phone or whatever it is. I get it. I get it. You have no income coming in, right? Especially if these caregiver children are not collecting Social Security yet, or if they didn't have a career and they don't have any kind of pension coming in, right? So, but we can solve for this, right? And so there's situations where, and this comes up in other cases as well, not just with caregiver children, but what we've talked about with caregiver children in these cases, and this might sound weird, is the idea of putting together a caregiver contract with the adult child. Now, you can't do this with a spouse, okay? Yeah, a birthday or Christmas check. So if everybody sees that question in the chat box, that's fine. Like a check at somebody's, mom or dad giving out checks for birthdays or Christmas or Hanukkah or whatever holidays you celebrate, or a wedding. As long as they're reasonable, that's okay. This isn't the time, 50 to $100, reasonable. Giving out like $200 to $500 checks, unreasonable. Now, even if that's something you were always doing, the problem is, if you're applying for Medicaid within 5 years and they see that you were giving out Christmas checks at $200 or $500 a pop, even if that's something you always did, they're going to take issue with it. I'm just letting you know that. So, even though I understand in a lot of these cases, people aren't doing it for the purpose of applying for Medicaid, I always tell my clients, I'm like, this isn't the time to start writing those big checks. But yeah, no, birthday checks, Christmas, Hanukkah, whatever holidays you celebrate, those are fine. Again, as long as they're reasonable. But I tell my clients, I'm like, you can use a caregiver, you can put together a caregiver contract with your son or daughter. And again, they're like, well, that sounds weird. I'm like, yeah, but you've been paying for your daughter's phone bill every month. You've been paying for your daughter's car payment every month. You are paying for all the groceries every month. And you're writing her a check for a couple $100 for her to have some spending money. So why is it weird? She's caring for you, right? We're just doing it in a way that will make things easier if you have to apply for Medicaid at some point. Now, what I'm saying might sound crazy. The problem is we do so much work with Medicaid that my concern for folks is that if they end up having to leave their house, because I get it. In a lot of these cases, the idea is these caregiver children are doing a lot to keep their parents at home. And the goal is, hey, I want to keep my mom or dad at home. I don't want them to go into a nursing home, right? I'm going to care for them in the house as much as I can, or for as long as I can. But there's a breaking point. There will be a point where we cannot care for our parents in our home or in their home, unfortunately. Okay? There just will be, at least for some people. And so if that happens, let's make sure that we've set ourselves up for success and not for a situation that will be very, very difficult and that will make a difficult situation more traumatic. So as weird as it might sound, we can put a caregiver contract in place between mom and daughter where we say, you know what? The going rate right now for a live-in caregiver who's, living with an individual and taking care of them, roughly 24 hours a day, but entitled to, 8 hours of sleep. I mean, the going rate these days, I want to say, is probably close to $350 or $400 a day. I don't know if it's $400, maybe it's $350 a day. So I typically tell my clients, I'm like, what's your son or daughter? I don't know. Make it $100 a day. That's $3,000 a month. And this works twofold. First of all, everything I'm recommending is on the up and up, guys. Just want to make sure you understand that. A couple things. Number one, this takes care of all the money that they're giving their son or daughter anyway. So it helps them pay for their cell phone bills and make all those payments that they're already making. And typically in all these situations, when mom or if and when mom or dad move out of the house into the nursing home and apply for Medicaid, there's always another concern at that point. And the concern is, how do I protect some of my money and leave it to my daughter? Or not just my daughter, but I've got another son and another daughter. How do I try to protect some of that to leave it to my kids? Because I don't want to spend all $200,000 that I have at the nursing home. I don't want to use all my money there. So if I put some of that money aside via this caregiver contract, in some cases, that caregiver child looks at it like saying, well, some of that's going to reimburse me for my time and effort. And some of that is money that I'll have on the side in case my mom or dad needs to apply for Medicaid at some point in the nursing home. I'll hold on to that money and I can use it for them. Because at some point, if they're on Medicaid rules have changed a little bit for those of you that don't know. Now, somebody that's on Medicaid, a single individual that's on Medicaid in a nursing home can have $17,500 in their name, as opposed to $2,000 that just went up in the last month. But maybe mom or dad will need things above and beyond that. So now I've got this money that we kind of set aside because of that caregiver contract, because dad was giving me $3,000 a month to care for him, which was way less than if dad hired a caregiving company, right? If dad hired a company, some licensed company up, I'm not going to say off the street. If he hired some licensed bonded company, you'd be looking at probably $12,000 a month or more. So it's far less than what would have been paid if there was a company that was hired. So there are smart ways to do this. Now, I know this is for the child caregiver, but one thing I want to make sure everybody understands is that for any of you that are in the situation I'm about to discuss, or any of you that have friends or family members that are, anybody that has a private caregiver, okay, not through an agency, that is being paid, I'm going to say, quote unquote, under the table, whether it's with cash, whether it is with a check, but they're not through an agency. please, please, if it's you or your friends or your family members or your work colleagues, please have them put a written contract in place with that person. Again, from a Medicaid standpoint, if that person ends up leaving their home, going into a nursing home and applying for Medicaid, all the money they paid that caregiver, very much like money that was given to an adult child to care for them in the home, without a written contract. The reason why these written contracts are so important is that any money that an adult, that a parent gives their kid to care for them, and not even just to care for them, but like to pay for their car payments or phone bills, or that the individual gives the private caregiver that's not hired through an agency where there's no written contract, any money given in those directions, if that person then goes into a nursing home and applies for Medicaid, when they do that 5-year look back and they look at their bank statements, they're going to look at all that money as a gift, even though those people were providing care. Without a written contract saying that they were providing care, they are going to call it, they are going to consider that money to have been gifted, and it will be an uphill battle to fight it and to argue otherwise. We've dealt with this, and it is tough. Okay, I promise you. So get out in front of it. And even if you're, midway through paying that caregiver, fine. You can't go back. You can't backdate a contract, but you can put a contract in place now, moving forward. And if Medicaid ever comes into play, you can always say, listen, we didn't know we needed one. Obviously, this was a caregiver. Look, we have a contract that started on, May 10th, 2023. With Julie, the caregiver. You saw that Julie, the caregiver, was being written checks for 2 years prior, put 2 and 2 together. I mean, we just didn't know that we needed a contract. A lot easier to make the argument in that situation than without having the contract, okay? All right, I don't want to beat a dead horse. Just, these are, the whole thing is tips and tricks. These are things that create huge problems, okay? Huge problems. When we have an adult child living at home, taking care of their parent, okay? So let me back into this. Let me back into this. So let's talk in the first person, so it makes it a lot easier. Let's say I'm a senior and my adult son has been caring for me in my home. And he's been caring for me for the last 3 years. Living with me, okay? Doesn't have his own home, living in my home. And it gets to a point where he can't care for me anymore. And I have to go into a nursing home. And also I'm pretty close to being tapped out of money. So I go into the nursing home, and shortly thereafter, I have to apply for Medicaid. The way that Medicaid works, and let's just say that I'm a single individual, I'm a widowed individual. Okay, so the way that the Medicaid works for a single person applying it in a nursing home. Again, so the rules have changed a little bit. I can have $17,500 of cash in my name. Now that's a total of checking accounts, savings accounts, IRAs, 401ks, cash value of life insurance policies, everything. Real estate as well. So it's not like I get $17,500 plus a house. $17,500 total. I get to keep $30 a month of my income, right? So if my income is $2,000 a month from Social Security, I can, let's say I've got a Medicare supplement and it costs $250 a month. I can pay for my Medicare supplement. I can keep my $30 and the rest of my income goes to the nursing home. Okay, that's my only contribution to the nursing home. And then there's the 5-year look back, right? They want to see, did I give anything away over the last 5 years? And let's just say I didn't. But here's the thing, I've got the house, right? In this situation, I own the house. Now let's say that my assets are under $17,500. So I can pretty much apply for Medicaid. I'm ready to apply. But I own the house. Now, if I did not have my son living in the house with me for the last 3 years, and taking care of me for the last 3 years, I would have to sell that house. I could still apply for Medicaid. I could get approved for Medicaid, but I'd have to sell the house. And once this house sold, I'd get kicked off of Medicaid temporarily. I'd have to spend all that money back down until I was under $17,500, and then I get back on Medicaid. However, there's a carve out in the Medicaid policy. And that says that if I have an adult child, and this is only for a child, this is not for a grandchild, it's not for a niece, it's not for a nephew. Now, if I was married, my spouse would be allowed to stay in the house. So there's a carve out for a spouse as well. So we don't need to be worried about a spouse being kicked out. But in this situation, being a single individual, there's a carve out in the Medicaid policy that says if I have an adult child that was living in my home and providing care for at least 2 years, leading up to the point where I left the house and moved into a long-term care facility, and then I applied for Medicaid thereafter, I can transfer the house to that adult child. And it is not considered a gift. It's not subject to that transfer of assets within the last 5 years. Okay. But it needs to be that adult child had to have been living with me for the last 2 years, at least 2 years, and caring for me. So it can't just be living with me. So it's not like my son just moved in with me 2 years ago, or my son moved in with me 5 years ago, and that's it. And then I had a stroke 2 months ago and I went into the nursing home. He needed to have been providing care, right? There's a big difference. My son could have moved in with me 5 years ago, provided no care. He was just living with me. We were just roommates. But then I was healthy and taking care of myself. And then all of a sudden, 2 months ago, I had a stroke. I went in the hospital, and then I went into the nursing home. The child caregiver exemption wouldn't work in that situation. So typically what we need in these situations is we need, I tell clients, I'm like, the adult child's going to have to, when we submit the Medicaid application, we're going to need to show paperwork from the adult child, pieces of mail with the adult child's name and the Medicaid applicant's address, ideally like a tax return showing that that's the address they use for their tax return. As much proof as we can show, a driver's license showing that's their home address. So first we need to show that that's their home address, because obviously the other thing that we have to be able to prove is that that's actually where they're living. It can't just be, my son's been my caregiver, but he's got his own home, 2 towns over. The whole, the public policy behind this is that they don't want to kick my son out of what has become his home when he's been caring for me, right? Because in Medicaid's, in the state's eyes, if it wasn't for my son caring for me for the last 2 years, I probably would have applied for Medicaid, and I would have been a drain on the state's resources a lot sooner, right? If we kind of think through this a little bit. So they want to do some good, The state's not great, but they do some good things. So, and then the other thing is that I always ask clients in these situations, I'm like, how good is your relationship with the doctor? Because the state's also going to want to make sure that, if they're going to want to see something from my doctor, seeing that I actually had a need for care 2 years ago, right? So ideally, the doctor would be willing to put something in writing saying, yeah, Matt has needed, a level of care at least to the level of assisted living for the last 2 years, for the last 3 years, or for the last 4 years. And to my knowledge, his son has been caring for him for that period of time. If a doctor's willing to write a letter like that, it's gold. But at least if we can get some kind of letter saying that, Matt's been my patient for the last 20 years, he's needed a pretty, strong level of care for the last 2 or 3 or 4 years. And to my knowledge, he's been cared for in the home, that mixed with, proof that my son's been living in the home for the last few years is typically good enough to be able to transfer the home. Another little caveat, if you will, I'm not gonna say it's really a tip or a trick, it's kind of a caveat, we'll call it, is when somebody's applying for Medicaid, if they have, so again, in this example, and not just this example, but if a single person's applying for Medicaid in a nursing home, like I said, you can have $17,500. If that's me and I'm applying for Medicaid and I can have $17,500, if I have any children that are recipients of SSDI, Social Security Disability, not SSI, okay, not supplemental security income. SSI is a needs-based benefit that you can have where you, similar to Medicaid, where you can have no more than, actually, I'm not sure if SSI has changed, because SSI used to be like Medicaid where you could have no more than $2,000 in your name. I wonder if that's gone up to $17,500 as well. To be determined. We don't really deal with SSI a whole lot in our office. So, but SSI was very much like Medicaid where you could only have a certain amount of money in your name. Okay, SSI was more of a needs-based benefit. With that aside, I'm not talking about SSI. If I'm applying for Medicaid in a nursing home and I have adult children that, or an adult child, frankly, that receives SSDI, Social Security Disability. Social Security Disability is not a needs-based benefit. I can have $1 million and receive Social Security Disability. It's based on a disability, right? It's not based on me not being able to, me living under the poverty level, which is more of why you would get SSI or Medicaid. If I have an adult child that receives SSDI, I can transfer an unlimited amount of my assets to that child and apply for Medicaid. And it would not be subject to the 5-year look back. It's a very, very random caveat and carve out to the Medicaid policy. We rarely see this come up, but it has a few times over the years. The only, I've talked about how Medicaid works for a single person. I want to talk about it, how it works for a married couple. And then that's about all I'm going to say. And then I'm happy to take some questions. So the difference in how Medicaid works for a married couple versus a single person, let me actually just pull this up on my end because Medicaid has made some changes this year and they're so new that I need to refresh my own memory on just some of these numbers. But like I said, for a single individual applying for Medicaid in a nursing home, I can have $17,500 in my name. I get to keep $30 a month of my income. And there's a 5-year look back, right? A 5-year look back to see what did I give away over the last 5 years. And I'll talk about what that look back, how that look back works in a second. If I'm married, okay, if I'm married and I'm the one going in the nursing home, I still get to keep $17,500. My wife, my spouse, can have $120,780, okay? Say $120,000 to make it easy. A house and a car in her name, okay? That's how much she can have in assets. That number has also gone up a little bit this year. Before this year, for at least since 2011 when I started doing this, it was $109,000. So it went up about $12,000, $11,000. So for my wife, she can have $120,780, a house and a car. And her income on a monthly basis, she can have $3,715 a month. And that number went up pretty significantly this year. That went up about $1,000 a month. That was about $2,700 a month for the last 11 plus years, which is pretty significant. That's like $12,000 extra a year that the spouse, we call her the community spouse. She lives in the community, not in the institution, that she can have on an annual basis. Okay. And then the 5-year look back applies to both of us. What does that mean? That means that they look at all of our bank accounts and they want to see what did we do with all of our money over the last 5 years. Doesn't matter if I'm the one going in the nursing home and she's not. They look at everything. And what they're looking for is they want to see, did we give anything away? And the way that it works is, let's just say that, I go into the nursing home, I apply for Medicaid. I've got less than 17,500 in my name. My wife's got, less than 120,000 in her name. She's got the house, a car. We're good. We're ready to apply. But they see that over the last 5 years, doesn't matter if it came out of her account, my account, or a joint account, there was $30,000 that we gave away to our kids or whoever. It was given away. It was not used for us. And let's just say the nursing home that I'm moving into costs $10,000 a month. What the state will say is, they'll say, Matt, you're approved. You're approved for Medicaid, but we're going to give you a 3-month penalty. Right? And the way they got a 3-month penalty is they're going to take the $30,000 gift, right? Transfer for less than fair market value. They're going to take that $30,000 gift and divide it by the monthly cost of care, right? And they're going to say, you gave away 3 months worth of care, right? If you didn't give that away, you wouldn't be applying for Medicaid for another 3 months, presumably. So you're approved for Medicaid, but rather than Medicaid starting May 1st, you're going to pay for May, June, July out of pocket, and Medicaid will start paying for you in August. Okay. So that's sort of how that penalty works. That's sort of how that look back works. That's how it works if they give us a penalty. All right, so it's the amount of the gift divided by the monthly cost of care, and that gives us the amount of months that they will penalize us. Okay, hope that's helpful. But all right, listen, it's 10:03. I know we've got until about 10:15. So let me see I know there's a question from before that I'll get to and answer, and then if there's any other questions, I am happy to take them. So back on the POA, sounds like you need a doctor to say one way or another. Yeah, I mean, I don't, yes and no. Majority of times I meet with people, I don't need a doctor to say that somebody has capacity. The average, I don't want to say the average client, but the average, 30, 40, 50, 60, 70-year-old couple that comes in, I'm not requesting it. It's typically somebody is typically upfront saying something to me that makes me tell them I need something in writing. And there's good reason, right? I don't think they probably don't want to come in and all of a sudden have me say, what's going on with your wife, or what's going on with your husband. I mean, I would assume they don't want to waste their time or my time. We've heard the phrase time is money. It would be sort of a waste of time if they were not honest and upfront. So yeah, it's not necessary in every case. There's typically something that's said to us that would make me then request the letter. I guess that's the best way for me to put it. Do you need to bring that doctor document with the POA to the bank to allow them to give you access to the person's account, or just the POA? So if I have a client that signs a power of attorney document, so they have already signed a power of attorney document, and then they become incapacitated later, then I'd recommend that. So let's say that I'm incapacitated and I already have a power of attorney that I've signed, and my wife is the person that I've appointed. She's called my agent. Based on the question, what I would recommend in that scenario is that my wife, as the agent, would bring my power of attorney document to the bank, along with a copy of the letter from the doctor saying that I am incapacitated, so that they would then put her on the account as the power of attorney, and they would also know to not allow me to transact any business on the account anymore. And this is really important. And it's a really good question. I'll just refer to you as S, because 90% of the time, and some of you guys might think this is crazy, it's not. 90% of the time when clients sign power of attorney documents for property, the financial power of attorney, it's effective immediately. Okay, a power of attorney for property can be effective either immediately upon execution or only upon a doctor putting something in writing saying that they're incapacitated. Most clients, at least in our office, and I'll tell you that most clients in general, because I have clients that come to us where they drafted power of attorney documents with other attorneys, and then, you know, those attorneys retire or they lose touch and they come to us to review or whatever. It's very common for people to have their power of attorney documents take effect immediately. And here's why. There's a convenience aspect, right? My power of attorney was effective immediately upon me signing it. I was, I don't know, 29 when I signed it, 30 years old. I think it was right before my wife and I got married. And the whole thing was, what if I was traveling? What if I was out of town and there was just something that my wife had to do on my behalf? The whole thing is, I obviously trust her to do things that I would need, that I want her to do for me. Why would I trust the person that I'm naming more if I'm incapacitated versus now? Right? And I would challenge you guys to just think about that a little bit. And again, especially for my older clients where they have capacity, they can definitely make their own decisions. But I've got clients that are older that just don't want to deal with certain things. It's easier for their kids, their power of attorney, to deal with their tax returns or to maybe pay some bills for them. So having that power of attorney take effect immediately makes sense. The reason why I'm saying all this is because in some cases, that power of attorney, and let's say in my example, my power of attorney is effective immediately. So that means that my wife could be going to the bank right now and writing checks in my name, which is fine. But again, if I'm incapacitated at some point, and so if somebody is incapacitated, it's very important for the financial institutions, for you to get a letter from the doctor. And again, you don't want this shouldn't be like, and there's also a difference between like dad makes bad decisions versus dad is incapacitated. And those are two different things. And a doctor will also recognize that those are two different things. A doctor's not going to put something in writing saying, you know, Matt's incapacitated if Matt just makes bad decisions. But if somebody is truly incapacitated and they should not be making financial decisions, and the doctor agrees, get something in writing from the doctor, give that to the financial institutions. The financial institutions will then only work with the power of attorney on file. They will not work with the individual anymore, and that's good, right? Because in some of those situations, right, maybe I'm writing checks and giving them to strangers, right? Or I'm pulling money out of the bank and I'm handing it to people on the street, or there's somebody that's taking advantage of me and I'm giving them money. So in a lot of these cases, taking that individual, that incapacitated individual, giving them no access to their account it's the right thing to do, right? It's like taking away somebody's car keys. You're preventing a bad thing from happening. So I hope that answers your question. Anything else?
Any other questions? Shocked we got through. Good job, Matt.
Yeah, thanks.
All right, if there's no other questions, you can either put it in the chat box real quick or contact me and I can pass the message on to Matt. Matt, we normally put your email in the chat box. Looks like we might have a question. I'll put your email in the chat box. So, awesome. Oh, there it is. Did you do it? Thank you. Yeah. All right, I'm going to close out. So thank you so much to Matt. Thanks for talking to us. Matt will be talking, I think you're not until September now, right?
I think we're taking the summer off. Sounds about right.
Summer off. Good job, Matt. Way to have some boundaries. So we'll see you in September for him. Our next talk is next Monday and next Tuesday at 11 a.m. It's about demystifying senior living. So if you have any questions about like senior community centers and programs, services from this talk today, we'll find more about that out Tuesday at 11 a.m. So thank you so much for being on the call today. Thank you again, Matt, and I will see you and I'll talk to you soon. All right, thank you so much.
Bye.
Bye, everyone.